What is trust administration and how is that different than probate? My name is Amanda Rocha. I am an estate planning and probate attorney in California, and I'm here to answer that question for you. Before I get into it, let me give you my contact information. You can find me on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or follow along on my social media. I'm at Amanda Rocha Law. So let me give you a little bit of an easy example. If you have a trust and you pass away and all of your assets are in your trust, then probate will not be necessary. But that doesn't mean that somebody doesn't have to do something when you pass away. That is called trust administration. When someone passes away, or even if you're incapacitated for a long period of time, the successor trustee or the currently acting trustee is going to follow the rules of the trust and do what it tells them to do. That's administering the trust. Sometimes it requires that person doing things outside of the trust. And I can give you a few examples. So one of them would be making sure that there are no liens or anything on the property that is nothing attached to the property that is in the trust. Dealing with any leftover litigation that the decedent had, or even filing documents with the county recorder's office, letting them know that title is going to change. None of that is actually in the trust as an instruction. In fact, a lot of it isn't in the trust as an instruction. The trust itself tells you what the grantor, the person who created the trust, intended to do, but it doesn't give you rules to follow and exactly what to do and when. That is trust administration. Many people hire an attorney to handle trust administration for them, walk them through all the steps to make sure, number one, that everything is done properly, and number two, that they aren't held liable for negligence or doing something incorrectly. How is that different than probate? Well, probate is what happens when you don't have a trust or you don't have any estate planning documents whatsoever, and your property has to be disseminated based on what the government thinks should happen to it. So probate goes through court. Trust administration typically doesn't go through court unless there's something going on where someone's arguing against something that has to do with the trust and contesting it, or if the trustee needs to ask the judge for instructions because the trust wasn't clear about a specific situation. Probate, on the other hand, when you don't have a trust and you don't have other estate planning documents, you have to file a petition to the court to basically disseminate this person's property to their heirs. You have to figure out who are their heirs, then you have to contact them, you have to make sure there aren't any creditors, and you then have to collect all of the property, take an inventory of it, have it appraised. It goes through a long 1 to multiple year process to actually get that property from the person who passed away, the decedent, to the next generation or whoever their heirs are. Whereas with a trust, you get to basically name whoever your beneficiaries are. They do not have to be your heirs. They could be anybody. And you don't have to go through court unless there are extraordinary issues. If you have questions about any of this, drop them in the comments below. I would love to speak with you about your trust or setting one up to avoid probate or assisting you in anything you have going on with your estate planning needs. You can contact me on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or follow along on social media at Amanda Rocha Law. Thank you.